Should I start, my lord?
Yes, yes.
So my mat number 1462.
Yeah, just.
Yes.
Mat number
1462 of 2023. Item number 49. 49, yes.
এইটা না yes লিখে নিয়েছো তো ওগুলো সব বের করে yes
No, so need not take the trouble to open the papers because I'll very precise. I know the court is tired for the last few days going on. So I don't like to put your lordship in further whirlpool by repeating the entire fact once again.
no,
My
we
lord,
know that you will not repeat, we know that.
I'm grateful, deeply obliged. He has the number of petitioner 237. 237. For obvious reason, I'm saying because I am not the spokesman of everyone. I'm really concerned about my own headache, own problem. 237. Only 237.
So MAT 1462 has been filed by 237
237.
persons. You are
And they never approach the Supreme Court. They, after passing of that order, where they are not immediately the party, I'll come to that, my lord. We approach the Honorable Court with a leave to prefer an appeal. That was granted. Yes, that was granted. Yes.
leave to appeal granted by which other?
September 4, 2023. These are all admitted positions. There's no problem.
Mr. Rasul Vishwas, this 44 appeals, na? 44 appeal. Please tell us apart the board preferred leave to appeal, board preferred substantial appeal. And please, can you give the numbers of those MATs where they filed leave to appeal?
All other than board, all leave to appeal.
Oh, all leave
All
to
leave to appeal because none of them were party to the
So all the leave to appeals were allowed. Then Justice Talukdar said that one part of the order is stayed, other part will continue. Against that, who went up in appeal? Board went up in appeal.
Board, along with 2-3
along with Mr. Bandopadhyay's client.
Bandopadhyay's client, Mr. Joydeep Kaur's client, and my lord, are one or two.
Please,
I will
assist us. If you can give a chart, it becomes easy.
I will. Next day, my lord, I will hand.
Chart master.
Yes, what did you say?
No, not for court.
No, what did you say?
Sometimes court says something we could not hear. So here also
Then we will also say about it.
Always.
So my first point will be, my lord, as we know, the persons who is coming to the court or other knocking the door of the temple of justice, he must come not only with a clean hand, but with a clean mind. What is the legal right? I could have understood, my lord, that well. It is stated, I was not aware. There's a publications. It was not published in that way that everybody should know. They are participated in the selections. They are all candidates. They participated. They then face everything. They pass through that particular process. When they found, I have lost. After 5 years, they woke up with a slumber. Very cleverly, my lord, the writ petition is prepared. In paragraph 18, if I'm not wrong, he says it's a public interest. Public interest. As my lord knows.
Paragraph 15 of the writ petition.
18, if I'm not wrong. Public. If I'm not wrong, I'll correct it, my lord. No problem. Kindly trouble to that, my lord. Either 15 or 18. To my knowledge, paragraph 18.
No, it did not say public interest litigation.
Type of public interest litigation term is used for obvious reasons.
Term not used.
I've seen it, my lord, somewhere.
4 নম্বর লাইন
Fourth,
4 নম্বর পেজ 35 35
paragraph 18. এটা কার্ডটা দিয়েছিস এটা? But it is there, my lord. I can assure you, my lord, I've seen.
it is said
Kindly see.
there is no delay.
There is no delay in filing public interest litigations. Very interesting. Very significant. Why that was done?
Where did you get public interest litigation? Yes or no?
Page paragraph কত?
18
Paragraph 18. Last.
লাস্টে 4টে লাইন
There is no delay. It starts with that. Have you got it, my lord?
কপি পেস্ট
5 years is no factor. There is no delay. There is no delay. And
Which is আমাদের বলছিল
in filing the public interest litigation, as the corruption is still continuing and normal single bench such and such. It's very funny. If it is a public interest litigations, the single judge cannot entertain the matter. And person having some interest in the lease of the litigations, he cannot approach.
Yes.
So, my lord, he has got no locus standi to challenge. If he either or, if he says these are public litigations, he cannot challenge. If it is a public litigation, single bench cannot hear the matter. So it is his statement. And if I am not wrong, it is due to my knowledge. Thank you very much. So this is really shocking, unfortunately. First, the enormous delay. Yes, as I've seen in so many cases, Supreme Court says, it doesn't matter. If I find there is some substance, we can interfere. But right from the beginning, he never approached the court with a clear mind, not only clear mind. It's equitable relief, there's no doubt about it. So this approach is totally illegal. And being failed, he just approached. Supreme Court has condemned that. I'll not take much time. I'll not disturb your lordship. My lord already tired. Argument, the factual aspect. And I'll not enter into the factor because I was not a party there. Why should I? Kindly see one judgment. My lord knows it. 2017 9 Supreme Court cases. I'll hand over all those judgment compiled and a 5 paragraphs note. 2017, though I'll file in compile. আমার গলা শুনতে পাচ্ছিস না, it is my discredit.
79 Supreme Court.
I remember in one case, I was arguing in Kondu number 18. You were Justice Mukulwar Mukherjee, Justice. If candidate, paragraph 4 to 12, I'm just spreading the white notes, which is normally not do, but if candidates participate in selection process, have you got it, my lord? It cannot subsequently turn around and question selection process or constitution of selection committee only because he was not selected. On fact fails, High Court erred in ignoring well-settled principle of law while rejecting objections to maintainability of the writ petitions. So after being failed, he participated in that. I could understood that, well, he has got no interest, but for the greater interest of the state and the public, he approached in the public interest litigations. That means if anything mischief is done, it will continue. No. Any other person come and say, here is the wrong, please correct it. But he is not, they are not permitted to approach. Because suppose if they are selected, they will accept everything. Oh, everything is all right. Because they could not succeed, they jump up after 5 years, they woke up on the slumber and they came with an unclean hand. And very unfortunate, they challenged the selection process. Good but indifferent. I'm not entering into the merit. So this is my first point, my lord. He has no legal right. That's a vital aspect.
Thank you, Mr.
Certainly, my lord can also, Mr. Manager, we are here. We are hearing you. You enter the marriage. No. Supreme Court says, if it is found that, well, person against whom the order is passed, he is not made a party, order should be set aside. Very short judgment, very well compact. That is reported in. I assure lordships, my lord, I will not take much time. Only question of law. I really like this judgment for obvious reasons. I'm being half a minute time.
When you are on the other side, you will not like the judgment.
My lord. Without me. Just a minute. আচ্ছা কপি আছে পেপার কভার বার কর না না ওটা দিলে এখন হবে না ভালো করে দেখতে পারে একবার That's very interesting judgment, very short judgment, one pack. I've seen only two honorable judges of the Supreme Court. They delivered this. There was one Justice G. and Azir also then was, and this one. Kindly take trouble to come at page. The gallery. Delete the chill. I'm being happy this time. না 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 আচ্ছা পেজে তো জাজমেন্টটা কোথায় গেল এর মধ্যে বুঝিস নি
Yes, Mr.
Yes. Kindly take trouble. Reported in 1996, 3 Supreme Court cases. I'll hand over the judgment.
1996.
1996, 3 Supreme Court cases, 587.
Paragraph.
There's one paragraph, very interesting, very short judgment. I'm reading. Why I'm referring, I'll come. Leave granted, we have heard the learned counsel of the both rights. It appears that the appointment of the first respondent was annulled by the proceeding dated such and such. Consequently, see such and such, learned counsel for the first respondent states that his client has lost interest. Very cleverly, I see. My lord, not cleverly in the morning. I wanted to withdraw for other reasons. But here, not that cleverly. Honestly, I must actually confess. But here, he's a very cleverly.
So,
Oh, everything.
unless you were caught on the wrong foot, you wouldn't have done it. And Mr. Banerjee is there. He will not leave you.
Since a phrase cause of action has arisen, he is not contesting the matter. It is not in dispute, which is very interesting, that the appellant was not a party to the impugned order dated 15 June 1993, made on way number such by the Tamil Nadu Administrative Tribunal Madras, without being implicated as a party. Appointment of Thomas was annulled by the impugned order. The tribunal, therefore, has committed grave error of law in upsetting his appointment when he was not made a party. The impugned order is set aside as regards the appellant. As regards the appellant. So that's why I'm not taking any risks or anything to enter the merit. Why should I? Supreme Court says, since you have not been able to the party, and here you only apply in case of 253 petitioners. I'm not speaking for the others.
1996, 3 years.
I'll give the judgment. Supreme Court could have said, all right, I'm setting aside, I go back, we are directing the authority to consider once again. Supreme Court said, no. It is set aside. It can't
Yes.
stand in the eye of law. So that's why what I'm on. Since we have not been implicated as a party, and no opportunity is given, which is a fundamental principle. The order was passed, and I've lost my job. What's wrong I've committed? I'm asking myself. Is it found by the court that, well, I'm a bad man, I've adopted wrong practice, illegal practice? I could have understood. No adjudication is me. Even my district, nobody called for to test. Nobody was examined. Malda, I'm from Malda, so totally.
All of you are from one district. All your petitioners are from one district.
Yes, Malda. Yes, Malda. Malda was never called for. No person was invited. All I want to examine. I cannot say court cannot do that. But under what circumstances, I will not answer. I will not into the merit.
Thank you, Mr.
So, my lord, what I'm on, my lord, law doesn't mean to be mere theoretical abstraction. It is an instrument to do justice. Is it justice which are what I've got? Is it really a justice? What wrong I've committed? I'm repeating it again. Now, my lord, another thing is this, my lord. Peculiar, my lord. Because it is not a public interest litigations, court has got its own restrictions. Because on the basis of postcard, my lord, even Justice Bhagavati entertained no problem. When my lord is seated in the public litigation bench, when I say, no, Mr. Banerjee, I've got the information. That is enough. After it is a public interest litigations. You are here to protect the interest of the public as a whole and the interest of the state also. This is not a public litigations. So whatever we have said as a petitioner, court certainly will restrict himself within that. There is a Supreme Court judgment, my lord, to that effect.
On the ground of
Court cannot travel beyond that pleadings. Because what is the distinction between? Yes, I'll give you the reference, my lord.
it has been argued, Mr. Banerjee. You are
Yes, if it is argued, it's all right. No, but why this judgment, particular judgment was cited or not, I do not know. Well, that is reported in, if it is cited, I do not know, 2003-8 Supreme Court cases. Page 40.
4-0.
40. If it is cited earlier, that's a different thing.
In the absence of pleadings, you cannot argue. That is the
That's a very why. Justice Murani, another judgment I cite, my lord, made a very beautiful distinction between the plaint and the writ petitions. Now, let me just finish it, my lord. Article 23, practice and procedure. Issue in question only to be considered. Disposal of the case on a point not raised by the parties and omission to decide the question raised held improper. So if I raise something, but it is not adjudicated, that is improper. If I do not raise, but court took the responsibility to decide this things, that is also improper. Here also, my lord, from the writ petition, absolutely vague. I am sure it is not drafted either Mr. Bhattacharya or Shamim. Some junior chile, they thought this is enough. They took a chance. After 5 years, all right, let us take a chance. Now they are trying to build something without having any foundations. This is really unfortunate. Where you have seated, my dear friend? Why court will take the burden? Today I cannot bring so many things and put it on your shoulder. Kindly, it's like sometimes in the lower court it is even, apni to sir janen, ei judgment dekhe neven. Are bhai, how is it? It's all burden on the court. So this is the case, my lord, where I'll hand over this judgment, my lord, that will it is improper. It should not be encouraged. Now, my lord, this is another judgment. My lord, you say something.
yes.
Asking me something, my lord.
No.
Which is reported in 1988 4 Supreme Court cases 534. 88.
84,
88.
88 Supreme Court cases.
88 4 Supreme Court cases 534.
কথা শুনতে পাচ্ছিস না?
Like the what?
534
Yes, my lord.
on the proposition.
I'm reading, my lord. As has been already noticed, although the point as to profiteering by the state was pleaded in the writ petitions before High Court as an abstract point of law, there is no reference to any material in support thereof. Even by saying some question of law will not do, there is a basic and fundamental difference between the plaint and the writ petition. Because plaint only mere fact. Then there is scope for now affidavit chief to be filed along with the plaint. then written statement, discovery of documents, evidence, all those things. But the writ petitions, what I moved, my lord, I must annex all the relevant document, point of law based on the question of fact. Point of law. There was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petitions. Before us also, no particular and no facts have been given in the special writ petitions or in the writ petition or in any affidavit. But the point has been sought to be substantiated at the time of hearing by referring to certain fact stated in the said writ petition. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by fact, the party raising the point, if he is the writ petitioner, must plead the proof such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded, or the evidence in support of such facts is not annexed to the writ petitions or to the counter affidavit, as the case may be, the court will not entertain the point. In this context, it will not be out of place to point out there is a distinction between the pleadings under Code of Civil Procedure and a writ petition or a counter affidavit. While in the pleadings, that is a plaint or written statement, the facts and not evidence are required to be pleaded. In a writ petitions or in the counter affidavit, not only the fact but also the evidence in proof of such fact have to be pleaded and annexed to it. So the point that has been raised before us by the appellant is not entertainable. So, my lord, why that was done? For various reasons. Because it is the original code, my lord. And process is only process.
Mr. Banerjee, this was argued.
My lord,
This was argued, Mr.
very well. If it's argued, I need not propose it. I was not there at that time. So
Thank you, Mr. Ganguly. Mr. Banerjee, thank you. Yes.
now, last but not least. Kindly appreciate one aspect. When there is serious civil consequences, court must be very serious and cautious. Today, my lord, after working for 5 years, it's very unfortunate when one of my client, he returned to his home. Tiny daughter just asked, Baba, tomorrow arju chuti? Tomorrow ki rojo chuti? My client couldn't answer. What wrong I have committed that I have been punished in this way? Article 21 totally violated. That's why I started. Law doesn't mean to be mere theoretical abstraction. It is an instrument to do justice and justice for all. Even a person commit a murder, he is also getting the opportunity. And I am not getting an opportunity.
Why you are before us?
No, my lord. That's why
Getting an opportunity.
No, that's why I cited the Supreme Court judgment. I did not enter into the merit. I said, no, why should I lose one forum? If my application contestant is rejected in the high court, he can welcome. Lordship need not bother. I'll come and disturb your lordship. My lord, I need protections.
Thank you, Mr. Banerjee. Yes. Next.
35.